Good afternoon. Thank you all for joining us today. I'm told we have folks not only from all around the country, but around the world as far as places from Belgium and Germany. So we're delighted to have you here. I'm Drew Gann. I'm co-chair of Venables Healthcare Regulatory Practice, and I've been practicing healthcare and life sciences work for the past 25 years. I'm going to be the moderator today. I'm delighted to welcome you to Venables San Francisco office and to introduce my co-panelists. We're going to first talk a little bit about the forum for today, which is we've picked a case study that's based on a fictitious company, and we're going to have 6 different fact patterns that will help elucidate a variety of issues, including FDA, fraud and abuse, intellectual property, HIPAA data privacy and security, cybersecurity, and intellectual property. So we're going to cover a lot of waterfront. Why don't we start by introducing my co-presenters. Mike?
Hi, my name is Mike Bloom. I'm in the regulatory group here at Venable. Most of my work focuses on government enforcement, focusing particularly on food and drug safety.
Hi, my name is Tora Johnson. I co-chair Venable's healthcare practice with Drew, and I'll be speaking today about the HIPAA implications for our medical device company.
Hi, I'm Jamie Vibert, and I do a lot of data security and cybersecurity work and some data protection work. I do that a lot for healthcare companies and life sciences companies. So I'll be focusing on the data security aspects of medical device manufacturing.
Hi, my name is Todd Halpern. I'm part of the Food and Drug Regulatory Group, and I focus on all sorts of matters involving FDA regulation.
Michelle Jackson, also in the FDA regulatory group, and I also am in the advertising and marketing practice group as well. I'm here to also talk about FDA compliance issues for our medical device company.
Albert Erdis. I am part of the IP litigation group in San Francisco. I focus on all aspects of IP litigation and patent counseling.
Great. One housekeeping issue. We welcome questions, which we're going to address at the end. So if you're online, you can put in a question at any time in the chat box. And if you're in the room today, you can use those cards to submit a question and give them to Michelle, who's in the back. So with that, let's kick off the first fact scenario. Next slide, please. So our fictitious company is called X Factor. They manufacture a device that's used to measure blood coagulability, which is the time it takes for someone's blood to clot. And the device is known as a coag. They're used by healthcare providers only in healthcare settings, and they're not connected to anything. So they don't have Bluetooth capability, or they're not connected to electronic medical records in the first scenario. So it's really simply a gauge. It's not unlike a digital thermometer in its complexity. It has very basic software associated with it, and it's a class 2 in vitro diagnostic device. Given that this is and it's been on the market for 20 years, I should add that. So Todd, given that this is an FDA cleared device, what sort of high level FDA regulations are they going to be subject to?
Yeah, thanks, Drew. So of course, we don't have the time today to go through the requirements that are drawn out by thousands of pages of FDA regulation and guidance. But truthfully, while the regulations are vast, they can really be boiled down to 3 basic things. One is are requirements relating to the way in which the product is manufactured. A second relates to requirements for notifying FDA of certain pieces of information, whether that be prior to marketing the device or on events that occur following marketing and distribution. And then a third relates to advertising and promotion and the rules that govern the scope of how far you can go in advertising and promoting the product. What's important is that each company has a system in place for managing the variety of requirements that emanate from those regulations. So for example, with respect to manufacturing quality, where there are hundreds, if not thousands, of specific requirements from the regulations, the question that you have to ask is, how does my organization need to be structured so that I can ensure that I've got every requirement covered? To what extent do I have processes in place that require me to, for example, maintain the right level of documentation that help me identify when problems occur so that I can make sure that to the extent that FDA has to be notified of certain events, that I've got a method for assessing each event and providing that notice to FDA. So in the advertising and promotion space, for example, do I have people who are looking at each advertising and each advertisement and each marketing vehicle to make sure that I am properly staying within the scope of what FDA rules permit? Because if not, the consequences can be serious. In fact, they could be existential to a company, regardless of the size.
Okay. Also, with a company that has a commercialized product that's particularly reimbursed by government healthcare programs, you're going to want to have a system in place for fraud and abuse compliance, specifically any relationship with a healthcare provider, which in this case is the client of the company, implicates fraud and abuse requirements. So things that are typical business practices in any other industry, like currying favor with your customer or entertaining them or doing other things that basically create value for them, can be viewed as fraud in the U.S. regulatory scheme. So it's very important to have a fraud and abuse compliance plan in place that addresses interactions with healthcare providers, among other things.
I will say one thing, though. So even though you have to worry about the FDA, in this particular scenario, there's no data. There's no data being stored on the device, and there's no data being transmitted. So from my perspective, no data, no problems, we're good there.
I'll chime in. So no data, no problems, no HIPAA, which is a great perspective for HIPAA privacy. The Office for Civil Rights within the Department of Health and Human Services, which enforces HIPAA privacy and security, has long recognized that the medical device manufacturer is not subject to HIPAA just because of its manufacturing activities. And perhaps interestingly, even if the medical device company, and so in this first scenario, there's no medical information, so there's no HIPAA implications, but even if X Factor were to receive patient information from the healthcare provider that's using the device in its efforts to advise and provide guidance to the provider on how to use COAG in this scenario, still not subject to HIPAA, although the Office for Civil Rights recognizes for HIPAA purposes that the manufacturer is a provider in this scenario and actually doing some treatment. It's deemed to be treating when it's advising the healthcare provider on how to use COAG. And that transmission of information is okay in the eyes of OCR. It's one provider speaking to another provider and exchanging medical information for treatment purposes. So, and it's okay that one's subject to HIPAA, the healthcare provider, and not the device manufacturer. And the reason why the device manufacturer isn't subject to HIPAA, even though it's a provider, to be subject to HIPAA as a provider, you need to be billing insurance. And typically, the medical device manufacturer is not billing insurance for electronically for its product. Instead, it's getting reimbursed by the healthcare provider, who may in turn bill insurance, and that makes the healthcare provider actually subject to HIPAA, along with the other services that it bills through to insurance companies. So, so they may even be, so in our scenario here, X Factor has sensitive information. Even though not subject to HIPAA, it really should have a data privacy program and reasonable security measures in place. But as Jamie said, no data, no problem. And in my perspective, even if there is data, no problem, no HIPAA.
Anyone else before we move on to the second scenario?
We did want to make sure that folks understood that violating FDA regulations comes potentially with some serious consequences. And those consequences, what could happen to a company is really left to the discretion of the regulators. So that if a company runs afoul of some of the things that Todd was describing, whether it's problems in the manufacturing or whether something is being sold for a use that it has not been cleared or approved for, there are a wide range of options that a regulator, that the FDA or the Department of Justice could look to fix the problem, ranging from a simple warning letter that says to the company you're doing something that is unlawful, to some kind of injunctive relief where there's a court-ordered change to the way you're running your business, to criminal prosecution. So in a serious enough case, and you find yourself potentially facing criminal liability, what can be concerning for a company is that is left largely to the discretion of the regulator and of the Department of Justice. So that a violation of the FDA rules can bring any one of those things depending on the circumstances.
And to echo Mike, that can also occur with respect to violation of fraud and abuse laws, including the anti-kickback statute. In addition to criminal and civil penalties, you can also be excluded from participating in government health care program, which can be a death knell to a lot of companies. So to keep in mind. Okay, next slide, please. So the second fact pattern is now that X Factor is creating Coag Now, which has more developed software and can now measure coagulability at home. They're still selling to healthcare providers, but the healthcare provider is now prescribing this to his or her patients for use at home. The product is now has a decreased size, it has increased battery life, and added a screen that allows adjustable font size. It's the Coag Now 10. And now it stores data. Also, if the patient has a medical issue with respect to coagulability that's outside some defined parameters, it will basically issue a loud warning to the patient to contact his or her provider. Alper, once you have a diagnostic device like this that's conceived during the developmental stage, what sort of intellectual property protections are worth considering?
So IP can be protected in a number of ways. A product name or even a product feature can be protected using trademarks. The technical and design aspects of the invention can be protected using patents, and competitive and proprietary aspects of the invention that the company wants to keep secret can be protected using trade secrets. Some best practices. A trademark must be used on a product in commerce. Although the product is still in the development phase, it's never too early to contact Trademark Counsel and run a trademark search to determine if similar products are using similar marks. With regard to patents, it's very important to develop an internal invention disclosure process by which inventors document and disclose the invention to in-house and outside counsel. This will help your patent attorney determine ultimately if you want to file a patent application in the first place, and it also documents inventorship. Now that the U.S. patent system has become a first-to-file system rather than a first-to-invent system, it's become increasingly important to file as early as possible either a provisional patent application, which acts as a placeholder, or a non-provisional application that ultimately is examined and granted. A trade secret is created by identifying, segregating, and protecting the proprietary information through reasonable steps. Some reasonable steps include NDAs, non-compete agreements, work-for-hire agreements, and the exit interview with your employees becomes increasingly important in this aspect of protecting a trade secret.
Yeah, so just to pick up on after the IP, what you also need to consider are the regulatory implications as the device is evolving. So, for example, if you think of it in terms of the three buckets or systems that I described, manufacturing, notification requirements, and then advertising and promotion, it's through those lenses you can assess to what extent your obligations to FDA are going to change as a result of these innovations to the device. So, for example, with respect to manufacturing quality, you should have a system in place that manages change controls so that any way in which you change the manufacturing process, the materials, the technology is properly assessed. You're validating that those materials will work and won't have a negative impact on the device, for example. You should also be assessing, you will need to assess whether or not additional notification will be required to FDA and perhaps even some sort of pre-market clearance or approval before you start distributing that new product. So there is, in fact, a guidance document that goes quite comprehensively through an analysis that needs to be performed to assess changes and whether or not it will require either a new 510K or the submission of something else to FDA. For example, a PMA, a pre-market approval application, if the change is such that it actually changes how the device might be classified by FDA from class 2 to 3. So in terms of the notification assessment, basically what you're trying to look at is the extent to which those changes could significantly impact the safety or effectiveness of the product. And I emphasized the word could here because it's not that they necessarily have to. The idea is, remember, you're trying to assess whether or not something needs to be essentially signed off on by FDA, whether it's cleared or approved, and that you have data that satisfies them that this changed device is going to be safe and effective in the marketplace. It's not whether or not that change will, in fact, impact safety or effectiveness. It's the possibility that's considered that drives whether or not new submission is required. So you're basically considering two types of changes: changes to the technology itself or changes to the intended use. So here, for example, you're not just adding functionality to the device, but you're actually changing the intended use, because whereas the old iteration of the product was operated exclusively by physicians, you're now envisioning home use. And so you have to consider whether or not that introduces an element, and frankly here it probably does, an element of risk that could significantly impact the safety or effectiveness of the device and therefore requires a new submission of some kind. It is also theoretically possible that the intended use or even a change in the technology will actually change the classification of the device. So as I referenced earlier, it could actually be the case that while the original device was on the market pursuant to a cleared 510K, that now in order to market the new device, the company has to submit a pre-market approval application that is accompanied by clinical studies to actually demonstrate the safety or effectiveness of the device. And just a brief word about advertising and promotion, that third bucket. If that new clearance or new approval is received, you then have to make sure that you've adjusted any policies or SOPs that may be in place so that your review committees or those that are responsible for the advertising of the product understand and have assessed the new scope of how they could market, so that they could determine with respect to each piece what the risk is that a regulator like FDA might view their new promotion as off-label relative to that new clearance or approval.
Todd, just a follow-up question. What sort of changes are not likely to require a new filing or new clinical data?
So remember that when I say change, I'm talking about literally any change. So let's say a change to a manufacturing process or a change to a material. And really the danger in generalizing is that as applied to any specific device, the same type of change could have an impact such that it requires a new submission, whereas relative to another type of device, the risk might be that it doesn't require it. So, and this is actually, I'm glad you're bringing up the question, Drew, because it brings up the point that FDA's regulations in many cases, particularly manufacturing quality, are very general, and they really leave it to the company to decide how those requirements relate in their specific application to a particular device. And so it's very important to be able to take those general principles that are drawn from the regulations in FDA's guidance document and make some individualized assessment as how they impact your specific device.
So Tora, no data, no problem. Now we have data. How does that change your mind?
Well, we don't necessarily have data.
Okay.
There's data on the device. So if X Factor stays away from that data and doesn't take the data from the device, it still has no problem. And I would say, though, that the provider who is now using or having data potentially from COAG now, if it's on site, it's going to be their asset, and they're going to have some issue around the security of that data, which I think Jamie will speak to in a minute. But because there is data, there is a possibility that it could find its way back to X Factor. It could be in that general scenario that we spoke about, or that I just spoke about, which is X Factor is in a treatment role in helping the healthcare provider with how to use the device and how to help the patient with the device. But you could also envision a scenario now where X Factor becomes a business associate of the healthcare provider because it's providing additional services to the healthcare provider. So I can think of two examples right off the bat. One is now we have complicated software on COAG now, and if there's troubleshooting that needs to happen, and X Factor has access to the medical information on it, then it would need to sign a business associate agreement with the healthcare provider. Or it may be doing some data analytics for the healthcare provider and getting data to do that analytics, such as proving a case as to the cost savings to the healthcare provider for using COAG now. So I see a scenario now where you want to have a discussion about ownership of data, particularly if you are the business associate. So if X Factor is the business associate of the healthcare provider, it's going to want to make sure, I think, that it has a right to de-identify the information that it has and to be able to use that de-identified information for its own purposes, such as perhaps looking at its value that it's adding and to be able to market itself and the cost savings that it can provide a healthcare provider. And even if they're not in that business associate role, they're in that treating role and they're having data, I wouldn't be surprised if the healthcare provider, particularly sophisticated, might try to exert some control over that data and actually try to limit X Factor. And that is assuming X Factor wants the data. I mean, there are scenarios where you want to stay as far away from the data as possible because it comes with liability.
And even if, so under that scenario, now there's data on the device, even if you're not a business associate, so you're not providing services to the healthcare provider, to the extent there's data on the device that you or your employees will come into contact with, you have obligations under several state laws. If you're a business associate under HIPAA, and even if you're not under the Federal Trade Commission's reasonable data security requirements, to protect the data on that device to the extent that it crosses your path. So the device malfunctions and it gets sent back to your manufacturing plant and it still has the personal information or PHI on the device from the patient. You need to make sure that you have a process in place. I mean, a lot of these themes for security are very, very similar to the ones that Todd talks about, right? You need a system in place for handling this data once it comes into your system. So you want to make sure, and it depends on what the data is and how it's stored, but you want to make sure that you have the reasonable practices around that. So it can be encrypting the device so that your employees can't get access to the personal information unless they have a PIN or some other access code. And it can also be being able to wipe the information prior to doing the troubleshooting that's required for that device.
Good. Alper, now that you've got a different screen, new battery, and software, does that mean you can get a new patent?
Well, there has been a considerable amount of recent case law regarding patent eligibility, particularly in the software space, but which also affects diagnostic devices. Laws of nature, natural phenomenon, abstract ideas are not patentable. Simply adding software or automating or computerizing what was once manual is not by itself patent eligible. This has been deemed by the Supreme Court to be an abstract idea. Likewise, detecting a naturally occurring event in the body using a known method of detection by itself is not patentable. Your patent attorney and the inventors really need to drill down and focus in on what's new about the device relative to what's conventional in the industry.
Great. Aaliyah, let's go to the next slide. So in our third fact pattern, we now have a connected device. It's called COAG IoT Now. Love that name. Very sexy,
Catchy,
right?
yeah.
Very catchy, yeah. It's connected via an app to other devices of the patient, like a fitness tracker and a phone, and it gets input from those devices and information from the patient regarding medicine and exercise. It also can communicate to the healthcare provider that can make decisions based on the app. So Michelle, now what thoughts do you have from an FDA regulatory standpoint?
Sure. So I have two big buckets of concerns from an FDA regulatory standpoint. The first has to do with the changes that you've actually made to the device. So as Todd explained a few minutes ago, any change that you make, you really need to evaluate whether you need new FDA clearance or approval for the device with these new changes. Here we've got two big changes. We've got connectivity, and we also have this new app that is going along with the product. So this was a Class 2 device cleared via the 510K pathway. We really need to look at whether these changes, again, could significantly affect the safety or effectiveness of the device, or whether it has a major change to the intended use. Again, I'm going to go out on a limb like Todd and say, yes, I think these changes would require a new FDA clearance or approval of the device. But what's also interesting is that you have this concept of the app here. And there's a question as to whether that is an accessory to the original device or whether it in its own right is a device by itself. So you really need to look closely at how the app is going to function, what types of data it's taking into account before it's providing the output. And the reason that that is important is that it may affect how you approach the FDA with regard to clearance or approval. So, for example, you might take the position that this is just an accessory to my previous device, and therefore I think FDA, I could maybe use a shorter process of clearance or approval, maybe a special 510K process, where I can build off of my previous applications to the agency. To make it a little bit easier for me. That may be an option in certain cases. In other cases, there is a new process with FDA for categorizing accessories in and of themselves. So you really want to look closely at whether this is an accessory, whether it's a device in its own right, and how, those factors can make a big difference with regard to how you approach the FDA for clearance or approval.
Could it also be a clinical decision support type of device, or would that make a difference if it has functionality that allows the physician to kind of make clinical decisions based on
Yes,
rather than just reading reading it out and giving a number if it has other functionality?
Yes, absolutely. Clinical decision support software has special considerations. Things like, does the device provide the physician with the underlying input or data that the physician can evaluate it on his or her own self to determine whether it would come up with the same output, or is there some kind of algorithm where it's just coming up with an answer and spitting it out, and the physician doesn't really see the input in how to come up with the decision. So all of that can make a difference with regard to the FDA classification as well.
Alpert, now what about on the patentability side, given that it's sort of making this into an accessory? How does that impact things?
No real impact. If a new feature in itself may be patentable regardless of if it's characterized as an accessory for FDA purposes.
Okay.
And so the second bucket of FDA concerns that I had, I know we talked about, do you need new FDA clearance or approval, is what implications this new connectivity and the app have with regard to your cybersecurity controls that you need to have in place. So from an FDA perspective, I see there as being sort of two categories of cybersecurity controls. There are those that you build into the design of the device or the software, and there are those controls that you need to have in place for monitoring and controlling cyber attacks, for lack of a better term. With regard to the design inputs, under FDA's quality system regulations, the QSRs, there are very specific requirements with regard to how you handle design inputs, how you document that, and how you're building in this protection into the device itself. And when you go to FDA for clearance or approval, FDA is going to be asking about that. They're going to ask, so what risks, what cybersecurity risks did you evaluate when you were building the software, developing the software, building the device? And how have you satisfied yourself that these controls are adequate to control for potential cybersecurity risks? So all of that is going to be important as you're developing this connectivity and also building in this defense for cybersecurity attacks. But you also need to validate your software. There's a software validation requirement under the quality system regulation to demonstrate that that software really is effective in protecting the device. And I know, Jamie, you probably have some thoughts about building in.
Super exciting for me. So I have quite a bit to say about this, but it's also where companies get a little bit nervous because most medical device manufacturers have had to deal with the FDA quite a bit, and less so with data and how to protect it. And so, as Michelle was talking about, there's the security by design piece, which is think about your security before you start engineering both the software for the device and your app. It's so much easier to put the security controls in place prior to the engineering of it than to do it afterwards. So it's something that really should be thought about at the very, very beginning, and it can help you understand whether or not that app or that device or holding a certain type of data is going to even be profitable for you as a medical device manufacturer if you start to think about what the controls are going to have to be prior to engineering the device. Then, so that's the design development phase. But then you also need to understand how you're going to continue to institute those controls throughout the life cycle of the device, which Michelle also mentioned. And that is the protection of the device and the app as the software changes, as the threats change, and as the vulnerabilities change. Now, the FDA has said that you should use the NIST cybersecurity framework. Under the HIPAA security rule, they also have a crossroad from the HIPAA security rule to the NIST cybersecurity framework. It is a very well-known cybersecurity risk assessment framework that you can use to identify exactly the types of risks that both your software on your medical device and the app are going to be facing. And so it walks you through a process where you identify what the data is and what the systems are that are potentially affected by this particular new device and app. You're looking at the assets that you have, so that's going to be whatever systems are touching this particular device and app. That's both backup systems and the systems that are on the device itself. You're going to identify any of the communication pathways that are happening between the device and from this fact pattern, your device and your app are now communicating with wearable technology so that it can get, let's just say, heart rate or steps or something else. It's communicating with the healthcare provider. So there are a lot of pathways of transmission of information that need to be protected. So that's in the identify stage of your risk assessment. You will go through and you will look and figure out where your particular vulnerabilities are going to be. So these communication pathways are typically vulnerabilities. The fact that you're going to have to update your software, that's a potential vulnerability. And your threats are what attackers might be coming after and how they might attack it. So you're looking at your vulnerabilities, you're looking at your threats, you're looking at the type of data and the systems that might be impacted. And then you look to what kind of controls you can put into place. And in different assessment frameworks, these are called different things. So you might have heard the people process technology set of controls. You might have heard administrative, technical, and physical safeguards. If you are living and breathing GDPR every day, it's organizational and technical measures. So these are all ways of describing the security controls that you can put into place over your device and your application. And these controls, unfortunately, are not a one-size-fits-all. It really depends on the particular device, but you need to look at these technical controls. So those are things like encryption, which I mentioned before, segmentation of information, firewalls, multi-factor access controls like multi-factor authentication, passwords, et cetera. These also include the process set of controls, so that's policies and procedures, which I know that that's important for a lot of different regulatory regimes, not just for security, and your people controls, and those are things like training and assigning rules and responsibilities. So these are all very important things to think about and to understand how you will both put them in from the beginning as well as continue to make sure that the device stays protected according to the risk throughout the life cycle of it. Now, the very, very first thing that you have to do before you can start this risk assessment is to understand what the data is and what the systems are. And in order to understand what data you have and where it should be, you want to think about the privacy implications as well.
Right, and there I think you have some choice. So Jamie talked about security by design. So how about a little bit of HIPAA applicability by design? It depends on your business model. So sticking with what we've done to date in these scenarios is that the medical device manufacturer is selling to the healthcare provider. And in this scenario now, let's just assume, therefore, that its customer is a healthcare provider who has said, I want an app to provide patient management services, including I want to be able to interface, I want the data to interface with the EMR, I want to give me a patient messaging feature, and in that scenario, the healthcare provider tells its patient, download the app. So very clearly a business associate model going on there. X factors then creating, receiving, maintaining, transmitting PHI on behalf of the healthcare provider. But there's a flip to that. We can flip the business model and say we're going to go direct to consumer now that we have this catchy app, and I'm going to sell right to individual folks. And if you do it that way, direct to consumer, you can avoid the HIPAA applicability, even to the extent that it still can interface with the EMR, but it's all being done at the direction of the individual as opposed to the provider dictating it. Although there are state laws that you need to take into consideration, and we're in California, so I need to at least specifically give a nod to the California Medical Information Act, which applies to app developers and is really a basic mini HIPAA. And I suspect, Jamie, not to put you on the spot, but to put you on the spot, when you're direct to consumer, you have a few thoughts on what that means.
So yes, so I talked a lot about what the security controls you can put into place are when you're specifically thinking about the device and how you train your employees and what policies and procedures you need to be put in place. But you can also protect yourself from a privacy policy and terms and conditions standpoint. So if you're going direct to consumer, you want to make sure that your privacy policy tells the consumer, Mr. Millennial, I'll call him. So you want to make sure that he knows what data you're collecting, where you're storing it, who you're giving it to, how you're giving it to them. You want to make sure that anything that you say about privacy or security is accurate. Otherwise, the FTC will certainly come knocking at your door and tell you that you have engaged in a deceptive trade practice. And you also want to make sure that you are telling people what they can and can't do with your device. So in this particular scenario, you want to make sure that you're telling your Mr. Millennial that he can't let his friend or his kid or his grandmother use the COAG IoT now, right? You don't want somebody other than the person who you think is using it to be using it. There could be all kinds. If it's a child, there could be COPPA implications for the child privacy. There could be all other sorts of implications. So you want to make sure that you put in your terms and conditions very specific items that you do not want them to do when they're using their device.
And I'll just add one last point. And if you can't make a decision, because it's hard to make a decision, you can do both models simultaneously. You just need to make sure you know when you're acting as a business associate and you're holding PHI, in the situation when you're a direct consumer and skirting possibly HIPAA, that you still have sensitive information that you want to keep secure and keep private, but not necessarily have to answer to the Office for Civil Rights.
Okay, next slide, please. So in our fourth fact pattern, X Factor now learns from a white hat cybersecurity researcher that there's malware now infecting the connected device. X Factor decides to investigate and determines that the malware reads and tracks communications and sends all that information to some unknown destination, but doesn't change the data. Michelle, what kind of issues does this raise on the FDA side?
Oh, a whole bunch, as you can imagine. So to Jamie's point, with regard to putting procedures and processes in place, that's actually a requirement under the FDA's regulations or quality system regulations, QSR, that you have written procedures that you follow for cybersecurity, among other things. So how are you detecting hazards? How is information coming in when people report that perhaps your device has been hacked? How are you handling all of that? You need to have written procedures in place telling the company this is how we're going to intake this information, this is how we're going to process it, investigate it, and how we're going to fix it, frankly. And there are other QSR requirements as well that come into play with this type of situation. So there are specific requirements in the QSR that describe how you need to be handling complaints. And I think FDA would say this is a complaint. So you need to have procedures for evaluating these and investigating all of these complaints. And among that, I think that's most important from the FDA perspective is evaluating the risk of patient harm. So I know that Jamie's probably got a different perspective from the FDA perspective.
I really don't care about patient harm.
She doesn't care about patient harm. And FDA doesn't care so much about privacy, but they do care about patient harm. So is this potential, or is this threat, could it potentially have an effect on patient health? It's going to be key from an FDA perspective. And if it were to be exploited. But there's also considerations with regard to FDA's QSR regulations have a requirement that you have a CAPA place, a corrective and preventive action program. And so that it requires that as you become aware of a problem, that you fully evaluate it, you investigate it, you fix it, and all of this needs to be documented. Sort of FDA's view is if it wasn't documented, it wasn't done, they kind of like don't believe you. Well, even if you tell me you did it, but you don't have documentation, then, they just don't think it was actually done. And so all of this needs to be documented as well as your validation of the changes. So if you've changed your software to protect against this potential threat, you need to evaluate it to determine and to validate the software changes to confirm that they, number one, are effective, but perhaps just as important, that the changes don't otherwise affect the safety or effectiveness of the device. So you could make changes, then you say, hey, I've stopped this cybersecurity risk, but in doing so, perhaps you've somehow altered the safety or effectiveness of the device, which is also of a huge concern to FDA. So you also need to document that these changes you're making are not altering the safety or effectiveness of the device in a manner in which you didn't intend.
So just to kind of step in there, I want to say that documentation is also required not just by the FDA, but it's also required by several state laws. It's required by the FTC's reasonable data security practices. It's required by the HIPAA security rule. So if you don't have an incident response plan in place, you should. And if you're a medical device manufacturer that has a connected device or an app or anything like that, your incident response plan should reference or coincide with or include the requirements for documentation under the FDA's CAP program. So they should work together so that you are doing the documentation that you need for other laws simultaneous with the documentation that you're going to need if a security incident. I would never use the word hack.
As you can tell, I'm an FDA attorney, not a.
None of our clients ever get hacked. But you want to make sure that you are checking all of the documentation boxes, and it's very similar under a lot of state laws. You have to have an after action report, which is very similar to the remediation process under the FDA's requirements. So you just want to make sure that you are aligned in your incident response procedures.
And some other FDA requirements in this type of situation would be consider that if you have to service the device, so if you've got devices that are in healthcare offices, clinics, and you're sending someone out to service that servicing needs to be done in compliance with FDA's quality system regulations as well. So keep that in mind. And then also evaluate how this threat may have affected your entire portfolio of devices. You may have the same software code and not just this device, but other devices, and FDA is going to expect that you have evaluated whether this same threat may apply to other devices that you have in your portfolio. So that's important as well. And keep in mind that when you make this type of change to try to remediate a threat, you have to so if the change is only to correct a potential cybersecurity threat, FDA says, well, that's just a patch or a device enhancement, and we don't really need to see that we don't need to clear the device again or give you a different new approval of the device. But where it could potentially make a difference is if that change also affects the safety or effectiveness of the device. So if we've had some situations recently in the past couple of years where device manufacturers have had their threats that they've remediated where the threat was an actual threat to patient harm. And in that situation where you've changed the safety or effectiveness of the device, you likely would have to go to FDA and get new clearance or approval for those changes. Thinking of one in particular where FDA made clear we've looked at the changes to this software and we approved it, and now you're free to go implement it. But otherwise, generally, if it's not a safety or effectiveness concern for the device, then you can just sort of make the change without having to get approval. If you are not a Class 2 device, if you've not had a 510K clearance and instead you had a pre-market approval application, a PMA, as Todd mentioned earlier, it can be a little bit different. There you would likely have to report the changes that you've made to FDA on your quarterly or annual filings, but you wouldn't have to go to FDA beforehand if it didn't affect the safety or effectiveness of the device.
Okay. Mike, how about reportability of the adverse event to FDA or implications for recall?
In this particular instance, you don't have to report this to the FDA. The reason stems from an analysis of whether the problem here is something that is controlled or uncontrolled. Those are the terms FDA uses to take a look at whether the malware here, or whether the defect in the software is exploitable. And if it is exploitable, what's the result in terms of patient harm? Here, there's clearly exploitable, but there is little or no chance of patient harm. So because of that, if there is any fix, the FDA would consider it, as the term Michelle used, a routine cybersecurity update or a device enhancement, which is a term the FDA uses for all kinds of changes to a device. So it's nothing that you have to report to FDA.
And that's just based on the risk to the patient?
It's based on to make it a little more nuanced. Imagine a graph, right, where on one axis of the graph is exploitability from low to high, and on the other axis of the graph is patient harm from none to critical patient harm. And you can plot along that graph where this particular problem fits. if it fits in a place where there is a high chance of patient harm and low to the moderate exploitability, you're going to have to report it. Here you don't, because there's no patient harm. So even though it's going to be exploited, it's not something that's reportable to FDA. Mm-hmm. Now, keep in mind, that's only the question is only, do you report to FDA? You don't have to do that here.
I've got the bad news, right? So or potentially bad news. So if you're subject to HIPAA and you're the business associate, you don't have to report to FDA. You don't actually have to report to the Office for Civil Rights, but you have to report up to your covered healthcare provider. And then the covered healthcare provider has the obligation to, assuming that it's unencrypted and you haven't followed Jamie's advice to encrypt everything, assuming it's unencrypted, then the covered entity provider here needs to do a risk assessment and consider about 4 factors, although they're not exclusive, to determine whether or not the information has been compromised. So under this fact scenario, there may not be any patient harm, but there may be a compromise of the data that requires the covered entity to report to the Office for Civil Rights and to the individuals. And the factors that the covered entity is going to consider is what was the information that was compromised, who received it, and was it actually acquired or viewed, and what has happened to mitigate the risk to that information. And again, right in this scenario where the business associate, we're just reporting up and laying it at the feet of the covered entity to make that decision. But you can bet that if the covered entity needs to report to the Office for Civil Rights, X Factor's name is going to be all over that report.
Right, and under state law, you could have reporting requirements directly to the patients themselves, unless the contract with your covered entity says otherwise. You likely have certain requirements under the state laws. Now, depending on the type of information you have, you could be subject to all 48 states' breach notification laws. If you only have medical information, then maybe it's only 9 of the states that you have to worry about. But there are very specific requirements in many of the states about what you have to report and to whom and when and how. And that can include reporting to governmental officials like state AGs and law enforcement and otherwise. So that's going to be a very detailed analysis. Even if you don't have to report to the OCR because you're only a business associate, you might have independent obligations to the patients themselves to report to them. I will also say that at this point, even if the FDA doesn't care because there's no patient harm, the FTC might care because there's been a disclosure of information. And even though nobody was hurt, that nobody was physically harmed, the FTC may still want to come after you and investigate the harm to the loss of this person's data. Or state AGs.
And all of that, if you go back to the original question here, is should you report to the FDA? All of that raises the next obvious question is, well, everybody else is going to learn about this. Why not just report it to the FDA to be conservative? The advice I'd give is that you don't need to. So you don't have to do it. Even though this is the agency that is approving your product, you can't even market it unless you have FDA approval. FDA is telling you don't need to report it. There really is no need to do it. All you are doing is inviting the FDA then to come in and take a look at your product and see what's wrong with it. And if you're confident that this is not going to cause patient harm, there's no need to report to the FDA. You don't need to be conservative about reporting it. They're not going to penalize you for that.
So, Jamie, you're doing the state law analysis, and in some states you may need to report because it's medical information. In other states you wouldn't need to report. Do you take the same view, or do you say report in all states?
It depends, right? It kind of depends on how close of a call you're making as to whether or not reporting is required under all of the states. So this is a risk analysis determination. If you're making a very close call that it's not required in some states because of a reading of this, a very strict, narrow reading of the statute, and you're reporting in other states, you might want to report to all of the states to be conservative. That's going to be a business decision that needs to happen kind of at your executive team level, particularly if people know that they are X factor users, right? So if you report to a couple of states and then somebody's reading the newspaper one day and says, hey, wait, I have an X factor device and I use this X factor app, and people in state A had their information compromised, I wonder if I was part of that compromise, and you call up and you have to say, yes, but I didn't have to notify you under your state's law. That's probably going to be a lot worse reputationally and from the state's perspective, who's going to look at this in hindsight, than it would have been if you had just reported in the first instance.
Are we helped at all by the fact that it's one device, one person? I mean, it's not like we've lost a laptop with thousands of names and of patient names on it, is it?
Well, it would be helped there if that were the case. I understood this fact pattern to be a larger scale,
Systemic kind of.
a more systemic type
okay.
attack. But to the extent that there's only one person, there's only one person.
And there's only one state.
And there's only one state.
Okay. Next slide, please. So now we've kind of mixed it up a little bit. It's basically the same as last time, except the malware can now reprogram the data. And if that happens, a patient can get indirect data about their coagulability, and it could impact the dosage of the blood thinner. So they're not aware, X Factor's not aware of any patient harm, but the potential for it, I guess, exists because of those facts. Michelle, back to you.
Yes, the same considerations that I just discussed in response to the last question apply here as well. All of the same quality system requirements, your response, how you're handling this will all be the same. It doesn't change that aspect of compliance from an FDA regulatory standpoint. But with regard to reporting, Mike, there may be a different analysis.
There's a different analysis when it comes to reporting to the FDA. And that's because of the potential for patient harm. Even though there has not been patient harm, the potential for it changes your point on the matrix. Right? So here, the defect likely would be considered uncontrolled. But because there has not been critical patient harm, whether you report depends on whether you do whether you comply with three things. First, within 30 days, you have to communicate to your customers and the user community generally that there is a vulnerability, that you have put in place some sort of remediation plan, and that there may be, if there are interim controls that you've put in, that you communicate that to those folks. Within 60 days, you have to fix the problem. So you got to make sure it's fixed. And then, provided that you are an active participant in an information sharing analysis organization, or ISAC, and you tell the ISAC about the problem, you do not have to report it to the FDA. The ISACs were created in response to an executive order from the White House some years ago, and it's meant to bring together stakeholders in all kinds of cybersecurity matters, so that folks can share information about cybersecurity weaknesses in particular products, or more broadly than products. The FDA has a memorandum of understanding with at least two of them. One is called the National Health Information Sharing and Analysis Center. The other is the Medical Device Innovation Safety and Security Consortium. So if you are a medical device manufacturer with a connected device and are interested in joining an ISAC, and you probably would want to at least start with those two. They are not the only ones. But in any event, the short answer is you do not have to report if you follow those three steps.
I just want to say one thing about ISACs real quick. So considering whether or not to join an information sharing organization is an important part of your risk assessment that you do under the NIST cybersecurity framework. I'm just going to say this: you get a lot of information from an ISAC. It is constant. It is hundreds of emails a day. So if you do not have the ability to take that information and actually look at it, from an FDA perspective, it's important, but you may be opening yourself up to some risk of being involved in an ISAC, but not actually using it for the purpose for which it was formed, which is to give you information. So if you don't have someone at your organization who can look at the threat intelligence that you're getting from the ISAC, you may not want to join and just flood somebody who can't handle that threat information.
Is there a risk also that you would be assumed to have known about threats that were disclosed on it, and if you didn't act on it, then you could have liability?
Right. It's not quite the same, but it's almost like having a policy in place that you don't follow.
Right.
And that's keep in mind that under FDA guidance with respect to reportability of a problem like this, it's just a matter of reporting. So if you make the business decision, as Jamie suggests, that joining an ISAC isn't the most effective or efficient thing for your organization to do, then if you have a problem that needs reporting, you just report it to FDA. You just have to balance the costs and benefits of all of those things together. The FDA's guidance is really just encouraging, incentivizing you to join the ISAC for some of the reasons that Jamie stated. But if it's not worth it for your organization, you don't do it. You just keep in mind that means that under certain circumstances you will have to report when you otherwise would not have to.
Yeah, it's a balancing act. I mean, all of this is a balancing act, right?
Okay, last slide, please. All right, in our parade of horribles, we just got to the worst parade. Here we've got the malware is now actually changing the data on the device, which has caused the doctor to change the patient's blood thinner dosage, and they have a clot, even though they're using the device. So, Mike, now what do we have?
Well, now you got to report. I mean, there's not really much question about it. The defect was exploited and it caused critical patient harm. It doesn't matter that it's only one person. That's enough. So you have to report to the FDA that under their standard MDR or medical device reporting regulations, you have to follow all those guidances. You have to report on the fix, whether it's a recall, which means sometimes just a corrective action. And you also have to fix it. Obviously, you'll have to notify your customers and the user community. You'll have to tell your ISAC if that is applicable.
And I have to say, I'm not saying that ISACs aren't important. They're very, very important. I'm just saying, don't do it if you don't have the capacity to do it. So sorry about that.
No, this one's, like I said, this one's simple. You got to report it.
And I'd say for the HIPAA analysis, you've got one more risk factor that the covered entity is going to take into consideration, which is the risk to the integrity of the data. And that comes clearly out of the OCR guidance on ransomware.
From a state perspective, both the last hypothetical and this one, so I said that we don't care about patient harm, but we actually do care about patient harm because there, under some state laws, there is a risk of harm, get out of jail free. If there's no risk of harm to the individual from the loss of their data, then potentially you don't have to report to that state. So if there is a risk of harm because of either the last one or in this one, then you may have to report. So we actually do care about patient harm sometimes.
And we're good people, so we care.
Of course.
All right, before questions, why don't we wrap up with some takeaways? So I'll start on the fraud and abuse side. Anytime you have a transfer of value to a provider, you're going to have a Sunshine Act reporting obligation. Anytime that you give a physician who's in a position to order the COAG product, anything of value, whether it's money for consulting fees, equity and X factor, entertainment, you're going to have a fraud and abuse issue that needs to be reviewed. Mike?
The FDA has put out a number of guidances on this particular problem of medical records, of cybersecurity in connected devices and so forth. They've done a lot of it recently. They're trying to be nimble. As you can imagine, they are simply not as nimble as industry is. So technology is going to change a lot faster than the government can keep up with it. What you're going to see then are a lot of the answers that FDA has provided today will not be answers tomorrow. So you have to it's one thing to pay attention to what the FDA is doing. That's not going to be enough. You should engage with good outside counsel early and often to figure out where you fit in any particular scenario you're facing.
So I guess on my part, it would be the old adage that a medical device company doesn't have any HIPAA obligations is changing as technology is changing. As you see mobile apps and you see connectivity, you need to be really certain about what information you're receiving, from who, and what capacity. And in any event, once you're getting medical information, even if you're not directly subject to OCR, you are subject to FTC and you're subject to state laws, and you need to have a privacy and security program.
So this is very, very similar. My point is that you should be thinking about your the risk posed by data from the beginning, because you can make decisions that help to alleviate that risk from the very beginning. And it's not only documentation and policies and procedures and putting the right controls into place, but it's decisions about what type of data you're going to take and when and how. And all of those are very important questions to deciding what that control, which could be expensive on the back end, is going to look like. So think about your data and your security from the beginning, and it will alleviate pains later.
And so mine would be, I could almost hear every member of a particularly small company bristle when I mentioned the need to have systems in place to manage what are vast FDA regulatory requirements. But I think they are important. Now, how elaborate those systems need to be can be driven by the size of the company, and also in particular the risk that's presented by the product. But as we saw here, the products change. And what we didn't talk about are how new legislation and new regulations are being promulgated all the time. And if you don't have a structure in place to somehow manage how you're going to keep track of what the requirements are as these changes take place, you're going to run into problems with compliance. And those issues, as Mike described earlier, can really be existential to companies, particularly smaller ones.
And I think my takeaway would be, as you're developing your medical device, your software, think about your future regulatory obligations. It sort of dovetails with what Jamie was just discussing in terms of when you're deciding what data you're going to accept or collect. Think about how the changes that you're making to your devices, or how you're developing your devices or software, what the implications for your FDA regulatory obligations will be down the line, because you can build things in at the early stages that will help you out significantly later on.
And excuse me, the IP takeaway, during the development stage of your product, it's really important to assess all aspects of IP, determine the appropriate form of protection, and develop a coherent IP strategy to maximize the value of your innovation. This process should be repeated as new features are added.
Great. So I'll just kick off a question myself, and then Michelle will take whatever questions you have in the group. So I'm going back to the popular TV show Homeland and the episode where some terrorists hacked into the vice president's pacemaker device and killed the vice president by taking control of the pacemaker device.
Spoiler alert, in case you haven't gotten to that episode of Homeland yet.
That's an example of how these issues trickle down to popular culture. But is there any distinction between security incidents, to use your term, Jamie, that don't aim at the data but aim at control of the device? I mean, does that change, the considerations that we've discussed today? Because I think most of the things that we think about are sort of data-driven, malware, or things that basically aim to sort of infiltrate and get access to data and do bad things with it. But what if it's the device itself and it's a life-threatening, potentially life-threatening device like a pacemaker?
So, and I think that this echoes a lot of what you've heard today. And yes, it does change because the regulations are frankly old and for a lot of states, and are focused on data But I think as time goes on, you will start to see significant changes in state legislation on what is a report, what you have to notify individuals and state regulatory governmental officials about. I think, you have the reporting requirements from the FDA. There are lots of different threats out there, and ransomware is one of them, where data is really not the issue. A distributed denial of service attack, which is a DDoS attack. We had a huge one in the fall of 2016 where I'm sure, Reddit went down and a bunch of other websites went down, and that's another type of attack where data is not really the issue. It's not going to take too long and the FTC has already started going after non-data driven type attacks like that. I think that you will see, as have some state AGs, including New York. California has a bill on the books specifically directed at connected devices, not just connected medical devices, but connected devices in general. So you will see the legislation catch up with the threats that are facing non-data driven attacks like that.
I think from an FDA perspective, the answer is it doesn't make a difference.
Right.
It's all about exploitability and patient harm, and not about that at all.
Right. There's a lot of patient harm in my example.
Yeah.
Okay, great. Michelle?
So we did have a few questions that came in. One of them is a question asking whether a healthcare provider can share patient information with the device manufacturer.
So that might be aimed towards me. And I touched on the concept a little bit. Depends on, again, what role are you in. If you are a treating medical device company and not in a business associate role, yep, that sharing can happen outside of the purview of HIPAA. It can also happen in the scenario of a business associate agreement with the healthcare provider if the medical device company is providing a service, such as the data analytics.
And there's also a question that seems to be related to conducting investigations. Is there risk if the company has investigation procedures, written procedures in place, but doesn't follow them?
That may be the answer is yes, and that's that goes to your QSR obligations. And if Michelle wants to jump in and correct me or supplement what I'm going to say is. You have requirements under FDA rules to have in place something called corrective action plans, and if you do not follow them, you can be you are violating your obligations under the QSR regulations, and that in and of itself is a problem. Even if, for instance, your investigation concerns a defect that is not reportable to FDA. If you do not follow, if you do your investigation, you do it wrong, or you don't follow your procedures, that is a violation separate and apart from anything about whether something is reportable, and you can have any number of enforcement actions against you because of it.
Yeah, I would just add that there was a warning letter just last year to a medical device company that had a cybersecurity threat that they evaluated, addressed, remediated. But FDA, when they were looking at the company's internal procedures for handling, for the corrective actions and procedures, they said, you handled this cybersecurity threat, but you did not follow your internal CAPA procedures. Therefore, we're going to ding you, and this is going to be an item on the warning letter that we're issuing to you. Despite the fact that you saw the threat, you addressed it, you fixed it, you didn't follow your own internal procedures in doing that, and that was enough to ding the company.
Yeah, and I'll just add that has broader applicability, right? So if you just pull back a little bit and look at what an FDA inspector is going to look at as they're going through a facility, I mean, it basically comes down to two basic things. One is, do you have the right policies and procedures in place to ensure compliance with FDA regulations? And then if so, or to the extent that you do, are those procedures being followed? So it makes it very easy for an inspector, if you have an SOP or a policy in place, that requires something that's not being followed, that's almost inevitably going to lead to some sort of finding against the company.
And just to tack on, I said this before, but this is also for your outward facing, right? So the FDA might be looking at something that's inward facing, but if you say something to the patients or to anyone else about what you're doing in terms of their privacy or their security, and you're not actually doing that, you're in trouble, not just with the FTC, but also probably with some class action plaintiffs.
Tor, is it the same calculus for HIPAA? It's whether you have the right policies in place and if you're following them?
That's right. They'll ding you twice. They'll ding you if you don't have the policy, and then they'll ding you for the policy, but you're not following it.
Right.
So if you have neither, then that's the choice.
There's what I think is a good follow-up question is what are the real risks in this current administration of government enforcement, FDA, DOJ, other agencies?
I can address that. Look, everybody reads the paper, right? So there's a perception and one that is seemingly actively encouraged by the current administration that regulatory activity will slow down, perhaps is one way to put it. And so the question is, are you really facing risk now? Has our risk calculus changed? I think the short answer to that is a very lawyerly one, which is, well, it depends. And it's going to depend really on whether, from a Department of Justice or a Food and Drug Administration perspective, it's going to depend on whether there's patient harm. And if there is patient harm or the risk of patient harm, then it's not going to matter who is in the leadership, politically or otherwise, you're going to have an issue. So for all the talk about changes in enforcement or pulling back a little bit, that's not going to be universally true. And I certainly would not rely on that if your product can be traced back to some sort of particular harm.
Tor, isn't it true that there's been more HIPAA enforcement, more settlements under the first year of Trump administration than the last couple of years of the Obama administration?
So 2017 was a bumper crop. It's been a little slow in and then it slowed down, right? 2016 to the beginning of 2017, there was a lot. Then it slowed down a bit, but we just saw one at the end of the year, or the beginning of this year. The time has blurred, but.
And to the extent that the federal agencies might not be coming after you, the more liberal state enforcement mechanisms like New York and California, they will definitely fill in any gaps that they perceive at the federal level 100%. And just from the FTC's perspective, I do think that they will change enforcement slightly on what they go after in terms of data harm, right? Harm that's solely because of the loss of data. I think that they have been talking about what consumer harm means, but in this particular scenario with a connected device and the potential for actual physical harm to a person, I don't think that you're going to see as much FTC slowdown for those types of security incidents that you might see for solely the loss of a credit card number, say.
And then your class action attorneys.
Yeah, they're not going anywhere.
And fraud enforcement is popular under any administration because it brings a lot of money back to the government, millions and millions of dollars. So I don't expect to see that decline at all.
Who doesn't like money?
Who doesn't like money? Right? No one likes fraud, so.
There's just one more question, and it's what is first to file versus first to invent?
Take that one. First to file means that the right to the invention lies with the first person to file a patent application, whereas first to invent means the right to the invention lies with the first person to invent, and that consists of conception and reduction to practice. Example of conception would be describing the invention in a lab notebook, and an example of reduction to practice would be developing a prototype that works for its intended purpose.
So if you're the first to file, but the person who's the first to file is not the first to, what was the other term?
First to invent.
Yeah, first to invent.
Under the old system, the first to invent would win. That's no longer the case now.
I think that's, unless we have questions in the room, those are the questions we have from the audience.
No? Great. Well, thanks again for joining us today. It's been a pleasure, and glad you could be here.